I want to start with the hiring process because this is really the first area in the employment life cycle, if you will, or business cycle of an employee's involvement with your organization, where things can start to go wrong, to put it frankly. So there are a lot of rules about hiring that relate to what you can and can't put in your ads, what you can and can't say in the interviewing process, what you can and can't use as reasons for your decision making. And we're going to go into some of those, obviously, as they relate to social media in particular. So a lot of the issues that arise in the hiring process would relate to the field of discrimination law. Most of the state and federal employment discrimination laws apply to the application or hiring process, as well as once employment is established. That's somewhat unique. Most other employment regulations pertain more limitedly to the situation where the employee is an employee. In other words, you have record keeping requirements, payroll requirements, and those types of things that apply to employees, but they don't all apply to applicants. The major discrimination laws that affect employees, at least in New York, are listed on this slide. The New York State Human Rights Law is the fairly omnibus employment discrimination law. Actually, the Human Rights Law does cover more than employment, but the important subset of what it covers is the employment relationship, and it prohibits discrimination based on a wide variety of topics, including most of the ones covered by various federal laws. Title VII, for example, prohibits discrimination based on sex, race, national origin, color, and religion. The ADA, the Americans with Disabilities Act, obviously prohibits discrimination based on disability. The ADEA, the Age Discrimination Employment Act, prohibits discrimination based on age for employees and applicants 40 years old or older. The Human Rights Law actually extends that coverage down to 18, so all adults are protected from employment-based age discrimination in New York. GINA is the Genetic Information Non-Disclosure Act, which prohibits discrimination based on genetic information. But GINA has some very important components that we're going to discuss in a little more detail because I think they particularly affect social media. Finally, New York's labor law, section 201D. There's not a really fancy name for this. There are some things that people have called it. For example, the smokers' rights law or the bungee jumping law, and you'll see why it's been referred to by those names when we move forward. In fact, we start right with that section 201D, the protection really in New York State for certain forms of employee off-duty conduct. The law says that employers cannot discriminate in connection with employment on the basis of employers' lawful political activities, use of consumable products, recreational activities, and union activity. So these are not immutable personal characteristics which are protected by the various other employment discrimination laws. These are things that employees can choose to do, and by choosing to do these activities, they are in effect gaining protection under this state law. This law is actually relatively unusual. There are not many states that have protections, at least that are this broad for some of these off-duty forms of conduct. But they are there in New York, and there are penalties for employers who discriminate against employees on these bases. The reason I really like to point this out in connection with hiring and social media is that if you think about the broad panoply of employment discrimination laws and then add in these forms of off-duty conduct that get protection in New York, it's really hard to figure out what you're going to find on social media that you can use to decide not to hire an individual. Just using this picture, for example, if you saw a picture on someone's Facebook account where they were drinking alcohol, and as long as they're old enough to do so and aren't obviously engaging in any other illegal activity, I think it would be relatively hard to deny that individual employment because you found that photograph. Suppose you could split hairs and make the argument that you're not taking the action because of their consumption of alcohol per se, but rather their judgment, and then placing the image on social media for everyone to see. The potential problem with that argument in itself is that recreational activities are also protected. Now, this law is, much older than social media itself. It's been around since the 1990s, and it protects things like hobbies, reading, watching television, etc. It's not limited in scope. So I think it's fair to say that one could argue that the use of social media itself in a legal way is a protected recreational activity, and therefore posting images of lawful activity is itself a lawful recreational activity protected by Section 201D of New York's labor law. I'm not aware of any cases that have been filed that make that argument or that even test the use of the internet or social media specifically as a recreational activity, but I suspect eventually we will see such a case. And again, it just leads me to wonder how much is left in New York specifically as a basis of denying someone employment based on what you find about them online. I mentioned the Genetic Information Non-Discrimination Act, or GINA, before. I think it is important to note this statute for a reason I'll get to in a minute, but I want to just make sure everyone understands first that the nature of genetic information is very broad, and I'm going to show you that in a second. It's not just the result of genetic tests, but for introductory purposes, let's note what I have on this slide, that GINA not only prohibits discrimination based on genetic information, it also prohibits employers from requesting, requiring, or purchasing genetic information of the employee or a family member of the employee. And the reason that I always put this in my social media discussions is that the regulations that the EEOC put out a number of years ago now were the first, at least federal regulations that specifically mentioned social media. I don't have it exactly worded as such up here on this slide, but generally the regulations make clear that a request includes conducting an internet search on an individual in a way that is likely to result in a covered entity obtaining genetic information. In other words, if you go to the internet, Google, for example, or social media platforms specifically, like Facebook, looking to find genetic information of applicants or employees, then you may be in violation of GINA for requesting genetic information, even though you haven't specifically asked the individual to provide you that information directly. Now you might be saying, well, wait a second, I'm not looking for genetic information, and what am I going to find on the internet, that's going to cross a line, because who's putting results of genetic tests out there? Well, the problem with that logic is that GINA defines genetic information basically to include all family medical history. I put up on the slide how far it expands, all sorts of relatives, several generations back in different directions. But importantly, it also includes all of those relatives of the individual's dependents, so children, obviously, as well as stepchildren and adopted children. In other words, an individual's genetic information includes the family medical history of people that are not even related to them by blood. So again, I think both the notion of genetic information, which extends beyond the results of genetic tests to family medical history, and the definition of family medical history itself are very broad under GINA, and it is, in my mind, quite possible that an internet search and a social media search could reveal family medical history. For example, evidence that the employee's parents or the employee's children have cancer or other medical conditions, which may or may not be of interest to a potential employer, but nonetheless are protected by federal law. And here is all of my contact information where you can follow up with me if you have any further questions. Thanks again.